Did you know that the exact same injury, the exact same accident, the exact same medical bills can be worth two completely different amounts of money, depending upon one single word? Most injured people have no idea there are two totally separate games being played when they file a claim. One game is called pre-litigation. The other is called litigation. And the gap between those two numbers can be tens of thousands of dollars, sometimes hundreds of thousands. I'm Steve Sweat. I've been a California personal injury attorney for 30 years. And in the next few minutes, I'm going to show you exactly why insurance adjusters go quiet the moment they hear the word litigation, and what happens to your offer the second a lawsuit actually gets served on their insured. So let's talk about the first category, the pre-litigation game, and how adjusters keep offers low. What's actually happening on the other side of that phone call when an insurance adjuster reaches out to you after an accident? That person has one job: close your file fast and cheap before you ever talk to an attorney who actually files lawsuits. That's it. That's their whole purpose. And the reason they move so quickly is because they know something you don't, that the offer they're allowed to make right now is a fraction of what your case is actually worth. Here's something most people don't realize. Pre-litigation adjusters have a hard ceiling on what they can offer. On a standard auto accident case in California, that ceiling is usually somewhere between $8,000 and $12,000 on the average case, I would say. They literally cannot go higher without getting supervisor approval. So when they call you 3 days after the accident and they say they want to help you get this case resolved quickly, what they're really saying is, let me close this file before you figure out what your case is actually worth. And they have tools to help them do that. Insurance companies run your claim through software systems that spit out a settlement number based on your medical bills and a few other factors. What that software cannot account for is a jury watching you walk into a courtroom. It cannot account for a judge ordering them to turn over their internal documents. It also can't account for what happens when skilled attorneys start asking uncomfortable questions under oath. There's also something called the MIST playbook, minor impact soft tissue. If your car didn't have a lot of visible damage, the adjuster is trained to use that against you. They'll say the impact was too minor to cause the injuries you're claiming. Doesn't matter how much pain you're in. Doesn't matter what your MRI shows. That's the argument they're going to make. And they're going to make it early and often. And then there's the old recorded statement. The adjuster calls you sometimes before you've even finished treating and says they just need to ask you a few questions to process your claim. Those questions are not here to help you. They're to lock you into answers before you know what your injuries actually are. A gap in treatment, a vague answer about your pain levels, a statement that the impact felt minor, all of that gets documented in your file and used against you later. And if you sign a release at that stage, the case is over. California has what's called a 1542 waiver, which means you give up not just the claims you know about today, but any claim you might discover later. A herniated disc that shows up on an MRI next month, a surgery your doctor says you're gonna need, gone, all of it. Once you sign, there's no going back. So let's talk about what happens when you say, we're filing a lawsuit. Here's where everything changes. The moment a complaint gets served on the other side, that file does not stay with the pre-litigation adjuster. It gets transferred to a litigation adjuster. Different person, different authority limits, completely different mindset. And now the insurance company has to go hire a defense attorney, someone billing at $300 to $400 an hour in California. And that clock starts running the day the complaint lands. Think about what that means. Every single month your case stays in litigation, the insurance company is writing checks to a defense attorney just to keep fighting you. That math gets uncomfortable for them quickly. And a boutique firm that has actually tried cases in front of California juries, that pressure is real. But it's not just the cost, it's what litigation opens up. Once you file a lawsuit, you get something called discovery. You can send document requests. You can send interrogatories, which are written questions they have to answer under oath. And you can take depositions, which means you can put their people in a chair with a court reporter in the room and ask them anything. On auto accident cases, I see this consistently. Cases sitting at $8,000 to $12,000 pre-litigation jump to $25,000 to $50,000 after a complaint gets filed. Not because the injuries changed, not because new medical records appeared out of thin air, because the cost-benefit math has changed for the insurance company the moment they realized they were actually going to have to fight this. On premises liability cases, slip and falls, trip and falls cases, where they dispute liability and usually offer nothing pre-litigation, those cases can go to 6 and even 7 figures once a lawsuit's been filed and discovery has been conducted. Because discovery is where you find out that the hazard had been there for years, that the property manager was never on site, that nobody logged a single maintenance complaint. That information does not exist until you file. You cannot get it any other way. So let's talk about the full picture here, liens, fees, and what you actually take home. Here's the part most attorneys won't talk you through, and it matters just as much as the gross settlement number. Filing a lawsuit isn't only about getting a bigger offer, it's about what actually lands in your pocket after everything gets paid out. Because a larger gross number doesn't automatically mean you take home more money. What you take home depends on what happens to your medical liens, and that's where settlement mills leave real money on the table. When you treat after an accident, medical providers put a lien on your case. That means they get paid out of your settlement. A lot of high volume firms, the ones that actually never go to trial, take whatever the lien holder demands because they're moving too fast to fight it. They've got hundreds of files stacking up. They need to close yours so they can get to the next one. So they accept the full lien amount, push the settlement through, and call it a day. A boutique litigator negotiates those liens down aggressively. After a lawsuit is filed, lien holders know the case has legs. They're more willing to reduce what they're owed to get paid. I've seen liens cut by 50% or more. And that difference goes directly to you. Run the math on it. Say two clients both have a $50,000 settlement and $20,000 in medical bills. Client one went with a settlement mill, full lien amount, no negotiation. Client two went with a litigator who fought the lien down into $10,000, let's say. Same gross settlement, but client walks away with $10,000 more in their pocket. Same case, completely different outcome. And the cost of defense pressure we talked about works in your favor here too. Every month, the insurance company is paying their defense attorney $400 an hour. They're burning through money just to delay. A firm that has actually stood in front of a California jury in Los Angeles carries weight when they say they're ready to try this case. That's not a bluff. That's a business calculation. And the insurance company knows the difference between firms that litigate and firms that just take the first offer and fold. One more thing. If you already gave a recorded statement before you got an attorney, don't panic. A skilled litigator can work around it, but it's exactly why you should never give one in the first place. The longer you wait to get proper representation, the more time the adjuster has to build a file full of gaps, inconsistencies, and statements that hurt you. Every week you wait is a week they're working against you. So here's what it all comes down to. The word litigation isn't just a legal term. It's the single biggest shift in leverage you have against an insurance company. It changes who handles your file, what authority they have, what information you can access, and what your case is actually worth. Your first step is simple. Do not give a recorded statement to any adjuster. Not your own insurance company, not the other side, before you talk to an attorney. That one mistake can follow your case all the way through to the end. If you've already gotten a lowball offer, or if the adjuster is pushing you to settle fast, that's a signal that's not in your favor. Call us for a free consultation at 866-966-5240 or visit victimslawyer.com. We'll look at exactly where your case stands and tell you straight whether filing a lawsuit makes sense. No pressure, no obligation, just answers.